1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်925ဦးဗန်စွမ်း Appellant vs. Dorothy and 5 others respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးစိန်သင်း Judge ဦးဗန်စွမ်း Appellant vs. Dorothy and 5 others respondents Suit for partition Parties have been in use and occupation of suit land jointly for several years, whether it was tantamount to creating by a contractual act unity of interest and unity of possession, which were the necessary ingredients for a suit for partition. The appellant sued Dorothy and Dr. King for a declaration that he is the sole owner of 2 pieces of land. He was successful in the trial court. However, on appeal, it was ruled that the suit land was joint ancestral property and that the appellant was not entitled to any declaration. Therefore, the respondents filed a suit for partition of the land against the appellant. Held so far as the evidence obtaining on the record of the lower court is concerned, it is probably clear that the plaintiffs and the defendant have been in use and occupation of the suit land jointly for several years. Thus, it may reasonably be inferred that up till the time when the defendant filed his suit for declaration, the parties have amended themselves and implied understanding to enjoin the property jointly. This was tantamount to creating by a contractual act unity of interest and unity of possession, which were the necessary ingredients for a suit for partition by any one of them against the others. It is therefore held that the trial court was justified in passing a decree for partition. Mountbatten vs. Matthew and 3 others, 5 Ren. 785. Mapwashin vs. Upo Sin, AIR. 1937 Ren. 324. Doso Shin vs. U Ang Pei, 1957, BLR 5. Mount Sin vs. Mount Biang and others, BLR 1942, 1946, 149, distinguished. Uba Dan 1 for the appellant, Uba O for the respondents. Usain Din Judge, in order to appreciate the stand taken by the plaintiff in the suit out of which this appeal has arisen, it will be necessary to reiterate in brief outline the history of the litigation between the parties. In Civil Regular Suit number 58 of 1960 of the late High Court, the plaintiff U Van Swan sued the defendants Dorothy and Dr. King for a declaration that he is the sole owner of 2 pieces of land known as allotments number 47 and 48 in block number 43C, Cantonment Circle, Rangoon. The plaintiff case was that these 2 allotments stood in the name of his grandmother Domyati since the year 1873, and that Domyati was in possession till her death. Domyati had 2 daughters, namely Donyei and Donyowa. the latter being the mother of the plaintiff SWAN, a few years before 1941 and also subsequently after that day, the defendants occupied part of the land with the permission of Donye and Donyowa. After the death of Donye and Donyowa, the plaintiff SWAN tried to mutate the land to his name, but on account of the objection raised by the defendants, he was not able to do so. The plaintiff therefore filed a declaratory suit against the defendants and for possession as against the defendant Dorothy, who was in occupation of a portion of this land. The defense raised by the defendants in a nutshell was that the suit land was not the sole property of Domyati and that the original owner was one Upo, father of Domyati, who had 3 children, namely Domyati, Upata, and Upe, and that on the death of Upo, the suit land devolved upon his 3 children in equal shares. It is also asserted that the property still remains undivided. SWAN was successful in the trial court, and a decree as proof was passed in his favor. But on appeal to this court, which was held by a bench of 2 judges in civil first appeal, numbered 103 of 1962, the bench ruled that the suit land was joint ancestral property and that therefore the plaintiff SWAN was not entitled to any declaration to the effect that he was the sole owner and that he was not entitled to a decree for possession in respect of the site occupied by Dorothy. The bench accordingly set aside the judgment and decree of the trial court, having been aimed with adjudication that the land was a joint ancestral property. The heirs of Upata and Upe, who are respondents in the present appeal before me, filed a suit against the appellant SWAN for partition of the land in civil regular suit number 66 of 1966 of the City Civil Court, Rangoon. By their claim, the plaintiff alleged that the suit land was joint ancestral property, which has not yet been divided, that the same originally belonged to Upo, on whose death about 60 years ago it devolved on his 3 children, Domyati, Upata, and Upe, in equal shares, that the plaintiff and the defendant, as representing the sole heirs of the aforesaid 3 children of Upo, are entitled per strip each to 1/3 of the suit land. That by consent of the defendant SWAN, the suit land was partitioned into 3 equal portions and that although SWAN was given the option to choose any of the 3, he had refused to do so. The defense cited by the defendant SWAN was one of total denial of the allegations set out in the plaint. In addition, it was also claimed that the suit in the present form was not maintainable and that it was also barred by limitation. Several issues were accordingly tried, but the most important were those relating to the maintainability of the suit and to the question regarding limitation. The trial court held that the suit in the present form was maintainable and that it was within time. a preliminary decree for partition was accordingly passed. Hence, the present appeal before me, in spite of the several grounds of appeal mentioned in the Memorandum of Appeal, the only point that has been seriously canvassed before me now is as regards the maintainability of the suit as framed before the lower court. U.A. Mao, the Land Counsel for the appellant, in support of his argument, cited a number of authorities in which the relevant dictum was that the Burmese Buddhist heir is not entitled to maintain a partition suit in the strict sense of the word, and his suit must be one for divisions of the inheritance, that is, an administration suit. No doubt, this dictum finds acceptance in various rulings, of which the leading case is that of Mangpa Vest, Matasu and 3 others, 1, wherein Tari Dash explained that a suit for partition and possession amongst Burmese Buddhist heirs is not maintainable in law, and that the only way in which one heir can obtain his share of the inheritance from the other heir is by an administration suit. The same view was also expressed in the case of Mapua Shin vs. Upo Sin 2, where the dictum referred to above was quoted with approval. Of late, this principle was adhered to even to the extent of disallowing in to the claim of a purchaser of landed property from one of the co-heirs on the ground that the latter share of inheritance will always remain indeterminate until the same is decided by means of an administration suit. 5. Dorsal Shin vs. Wu P. 3. There is thus a consensus of opinion that among Burmese Buddhist heirs, the only manner in which one heir can obtain his share of the inheritance from another heir or heirs in possession thereof is by an administration suit, and the whole of the property belonging to the estate must be brought into account. No doubt, a casual reading of the Privy Council ruling in the case of Mount Sin vs. Mount Biao and others, 4, indicates a seeming departure from the aforementioned rule, inasmuch as it was observed by their lordship of the Privy Council that though the suit is not for the administration of the estate, nor was there a claim for administration or for the accounts, and the subject matter may be only for a portion of the estate, it is not only competent for the court to ascertain and declare the shares of the heirs or the parties, but also it is its plain duty to do so. But in the case cited above, the suit was based on an award made by the arbitrators, and the plaintiff was merely seeking for a declaration that she is entitled to more than what the arbitrators had awarded her. The cause of action was not the death of the ancestor whose estate was sought to be administered. It is therefore clear that the above observation made by their lordship of the Privy Council do not in any way affect the dictum which has all along been observed in the matter of the claim among Burmese Buddhist co-heirs. But this does not dispose of the present appeal before me inasmuch as the circumstances obtaining in this case are entirely different from the ones D, which in the above rulings, the principle under which a Burmese Buddhist heir is precluded from filing a partition suit is founded on the legal incident that the estate of the deceased Burmese Buddhist vests in the heirs on the death of the ancestor, and that they are tenants common and not joint tenants of the inheritance. For, strictly speaking, partition is applicable only to those suits in which the plaintiff seeks to convert his joint ownership and joint possession of the whole property into separate ownership and separate possession of a portion of the property. Therefore, a partition suit lies only when the plaintiff and the defendant have unity of interest or title in the property sought to be partitioned, and that there was also unity of possession, which does not seem to be the position of the Burmese Buddhist co-heirs at the time of the death of their ancestor, but if the heirs, by an agreement express or implied, remain in possession of the estate of the ancestor jointly and continue to enjoy that estate jointly, then they have created as among themselves, by a contractual act, unity of interest and unity of possession, which would enable one of the heirs to file a suit for partition. This is the view expressed in Mambadu case, Subra, and with respect, I have not the slightest doubt that it must be so, otherwise it would cause undue hardship if after enjoying joint possession of an inheritance for several years, Burmese Buddhist co-heirs were to be driven to an administration suit as the only way to get their shares of inheritance. An administration suit has as its object the taking of accounts as a step to the administration of the estate under a degree of the court, and its essence therefore is for accounts and for application of the estate of the deceased, for the satisfaction of the dues of all the creditors and for the benefit of all the creditors and all other heirs who are entitled to share in the estate. But in a case such as the one before me, where the deceased whose property is sought to be partitioned died over half a century ago, it would be difficult, if not well nigh impossible, to bring into account all the properties which existed at the time of his death. Thus, it seemed clear to me that, in the circumstances of the case, the suit as framed in the lower court cannot be said to be inappropriate. So far as the evidence obtaining on the record of the lower court is concerned, it is probably clear that, as pointed out by the learned trial judge in his judgment, that the plaintiff and the defendant have been in use and occupation of the suit land jointly for several years. Thus, it may reasonably be inferred that up till the time when the defendant filed his suit for declaration, the parties have among themselves an implied understanding to enjoy the property jointly. This was tantamount to creating, by a contractual act, unity of interest and unity of possession, which were the necessary ingredients for a suit for partition by any one of them against the others. I would therefore hold that the trial court was justified in passing a decree for partition. It is, however, noticed that the decree drawn up is not in conformity with the judgment inasmuch as the plot number 3, which is the defendant's share, is ordered to be partitioned. The decree should be for partition of the entire suit land into 3 equal portions, and the plaintiff to be put into possession of 2 of the aforesaid portions. The decree will accordingly be amended in the light of the aforesaid remark. Subject to this amendment, the appeal is dismissed with no order as to cause.